Thank you for joining us for North Alabama Law Review, presented by Johnston, Weston. I am your host, Shauna Hill, and today we have joining us our managing partner, Christopher Weston, and our lead in family law, Mickey Gentle. Today's trending topic is about AI technology in the legal field and what to watch out for to avoid many mistakes. What is your viewpoint on AI technology coming into today's industry?
Well, as you know, being someone involved in management and management duties in a law firm, we have to be extremely careful with anything new. So AI, while it is a very useful tool, or can be, and seems to have a lot of potential in the legal framework, is that we are dealing with people's lives. And so just think, how much of your life would you want actually turned over to be managed by a computer? Okay, and so that's what we have to deal with. In terms of law, and that's where our industry is extraordinarily unique, is that law is created over decades, centuries, sometimes millennia, and there's a ton of development. And so anything new, by necessity, has to be slow to integrate. It has to be tried, it has to be tested, it has to be evaluated, it has to be limited and expanded back and forth until you find the right balance in dealing with someone's life, okay? And so at our firm here, we do not allow the use of AI technology to potentially its fullest extent, okay? And so, you know, we do permit its use for brainstorming or ideas, provided it's on a secure network, that it is a limited form of AI, because again, we cannot and will not put client information out into a general AI generator, because then we don't have control of where it goes. And so AI use at our firm is prohibited outside of certain very, very specific exceptions. If you're brainstorming general ideas, if you're going to teach a CLE, or you're going to engage in talking points on something that is very general, you can be permitted to use it, provided it is sealed within our own network. And so you can have AIs that are limited to only your server, and they can't get outside info, they can't go, you know, and they can't go in, they can't share it. And so you have to set these firm boundaries for confidentiality reasons. But also, when dealing with AI, is nothing's going to beat the human brain and ingenuity. And, you know, I'm a big fan of science fiction myself. Frank Herbert wrote an entire series of books, the entire Dune series of books, regarding this exact issue. But I think as it develops, I think it will find its place in the industry. I don't think we should ever allow it to take the place of people and the imagination and the creativity that we have, because the best thing to understand a person is another person, because we all share the same experiences in one form or another. And so you have to be very careful, because AI can hallucinate different forms of case law. It can put in points that it thinks should be in there but are not. And you wouldn't want a lawyer doing that. And so something you don't have control over, or something you do not double check, you have to be very careful of. What AI is good at is maybe giving you ideas that you had not considered, different viewpoints. They're never going to give you an argument that you should use, but it might create a few trigger points, a few thoughts that you have, where it's like, oh, maybe I could look down this path in when I'm expressing this to a jury, to a judge, to a client, or again, in a CLE, which is a lawyer learning class. So it is a great source of potential ideas, but the actual product, the actual arguments, the actual litigation needs to come from human experience to be persuasive. Hence, it needs to come from a human. Definitely. I hope that helps.
Yeah, I definitely agree. AI technology is definitely something we need, but we have to be cautious of, like you mentioned, hallucinations and creating false case law. Definitely have to be cautious of the new technology as we navigate into it. Mickey, what do you have to say about AI technology in today's law firm?
I do think there is a place for the use of AI in assisting the lawyer in certain research, thought processes. determining what could be argued in a courtroom. And so there is a good use for that for those purposes. But as Chris alluded to, one does need to be very careful in how that's used such that it doesn't get into the wrong hands or out into a public arena, thus breaching attorney-client confidentiality. So.
Very good points to make. Okay, well, we're going to jump into a couple questions that we have received that we are hoping that you guys can give your expert insight on for. So the first one is going to be child support and custody modifications. So we have a question of if we want to modify our current custody agreement or child support agreement, what would be the steps to go about that, and what do we kind of need to look out for when doing so?
Okay. So when there is a modification, there's an existing decree either for child support or for child custody or for both. And in modifying those, obviously the first step is to file that petition for modification and set forth the grounds for the modification and explain to the court why that modification is necessary in the opinion of the petitioner. Once that petition is filed, it needs to be served on the opposing party. Depending on which court it's filed in, the person who receives those papers would have 14 or 30 days to file a response. For the modification of child support, the prevailing viewpoint is that the modification would have to yield a difference of 10%. So in other words, if you are the petitioning party seeking to increase the child support, the calculations would need to increase by 10%, or if you were the party seeking to lower child support, then the calculations would need to decrease by 10%, thus creating a presumption that a material change in circumstances has occurred that would warrant that modification. If we're talking about modifying custody, there are other considerations to take into account. In some cases, it boils down to the best interest of the child. In other cases, it boils down to determining whether the inherent harms that would occur to the child by removing the child from one place and putting the child in another would be outweighed by the good that it would do that child. So in other words, when you consider that a child is living with one parent pursuant to some decree, and the other parent wishes to modify that custody, in those cases where that standard applies, the court would have to take into account what those inherent harms would be and determine that the good that it would do that child would outweigh those inherent harms.
Gotcha. Those are very factors to consider.
Those are the main factors. Now, the code lists a number of factors that the court must consider, and there are a good number of those. And but that's among them, and that's what the court really hones in on.
Okay. Very valuable information. Thank you for that.
You know, I'd like to jump in, Mickey, if that's okay, with, you know, some of my experience back when I dealt with some family law stuff is exactly what Mickey touched on is that this material change in circumstances, really people need to understand that this is not a small change. It's not a small irritant. It is not something that can be, you know, easily overlooked. It has to be something that is legitimately material. Like on the child support side, this 10%, that's material. Or if you're changing custody, it has to outweigh, I mean, is whatever change you are trying to make, the good from that change has to outweigh affecting that child's schedule. And that is something where, Mickey, you are an absolute master at that. It's amazing to watch you do it. And, you know, but something I always used to try to convey to clients myself is that material doesn't mean merely significant. It means something material. It has to be a change in that child's life. And it needs to be a necessary change or as close to one as you can get it.
Gotcha. Very good information. Okay. Our next question is regarding PFAs. which is also known as protection orders. So the question would be, how would someone obtain a protection order, and how would they be able to go through the steps of obtaining one? What is required?
The typical process is that there is some sort of a vetting at the very beginning. In Madison County, for example, one would go to the warrant magistrate, and then that would be evaluated, and that person would be taken before a judge to be able to tell his or her story to that judge. That's called an ex parte hearing. An ex parte means that the person is going in there with or without their own attorney, but the other side is not present. There's not another attorney in there representing that person either. It's just that person or that person with their attorney telling the judge his or her story. The judge feels that the ex parte order is warranted. Now, that judge is satisfied that, from what I have heard, there's enough here to warrant my issuing this ex parte order. Then that gets issued, and then a final order, then a final hearing is set. And that how that is done varies with the counties. But typically speaking, that date is set the day that the ex parte order is handed down. And then there will be a final hearing where that other side has the opportunity to present his or her argument against the protection from abuse.
See, I deal with this a little bit on the other side, not so much in the representing parties who are getting a PFA like Mickey does, but I'll deal with some of the civil end that's just starting to develop. Like when I talked about AI, I was discussing, how the law evolves. And so these PFAs were very, very necessary to protect harmed parties, women, children, and men, from abuse or harassment or potential harm from a paramour or a former paramour or a spouse. And they were very, very necessary. But as time has gone on, we started to see the occasional, and not too bad, but we see the occasional abuse of these. And so on the civil side, which is a lot more what I handle in, is we're starting to see development of litigation, civil lawsuits for people who falsely present these. And again, it's developing, it's very new. Where the boundaries are is not entirely known yet, but it is a developing area of law.
I can see that, especially in the times that we're living in, where we have the Me Too movement going on, and a bunch of cases in that area. So do you have anything you would like to say about the consequences of obtaining a protection order under false information?
Yes, Mickey, if you want to take this, or you want me to jump in?
Certainly, filing a petition with false allegations in there could yield perjury charges. I think contempt might be involved in there as well. And certainly I have had a few cases where that has been the issue, where someone has filed a blatantly false petition. And because when you are filing that petition, you're swearing to the truth of that. When you go into the courtroom, you're swearing to what you're testifying to as being the truth and the whole truth and nothing but the truth. So certainly filing something and testifying to something falsely is perjury.
Yeah, there's a general rule of thumb, and I'll turn this way to just tell everyone at home: do not ever lie to a judge. Nothing good's going to come from it. And that is, advice that we always stand by. You can definitely catch perjury charges. There's contempt in certain instances. You can be held civilly liable for abuse of process, for fraud, for misrepresentation, for several different types of claims, depending on how egregious it is. And so the reality is that if it's severe enough to come to court, it is severe enough to tell the truth about.
Agreed. Very much agreed.
And I'd like to address, as you had mentioned, the Me Too movement. And, all movements start out usually from an aggrieved party. and they usually, start out very, very legitimate. But anytime you get sufficient numbers of people, there's going to be either misunderstandings, there's going to be people who are trying to take advantage of it, or people who literally are mistaken. It really has to deal with the percentages of people that we're dealing with. A certain percentage are generally going to use and or misuse it as you go forward. And so that's, again, where you need, human beings involved who have discretion, who are not operating off just set parameters, but have life experience, including the random and chaotic things that happen. And that also kind of goes back to that original topic of AI and why it has its use, but it also has its limits. You know what I mean?
Very valuable information. Thank you. We are going to turn to our next question. So our next question is a little bit outside of family law. So Chris, this is going to be more in your area of expertise. We're going to talk about storm damage and dealing with insurance claims and insurance companies and how to navigate that process. So our first question is, I recently had storm damage to my home. The insurance company does not want to cover all the damages. When should I get an attorney? How long does the process take to resolve? And do I have a right to use my own contractor?
Okay. Whenever you're dealing with insurance, you are dealing with a contract. That's what insurance is. And so every case is going to be slightly different based on the terms of that contract. You also have to deal with the fact that there are different insurance companies, different contracts, certain things that have been litigated and boundaries set, certain things that have not. And so the information I'm going to give you now is not so much general in nature, it's things that will generally apply. So I'll give you some specifics on that, but do be aware that your situation could and or will be unique. These things do not fall into a pattern just on their own. And so because of each case being unique or having the possibility of being unique due to the contract, the company, the facts and circumstances, the type of damage, what I always recommend whenever you're dealing with a contract or you're having a disagreement with someone on the other end of a contract, or in this case with your insurance company, it is always a good idea to have a lawyer review it. You can do something that's called a consultation, where you are under no obligation whatsoever to retain a lawyer. Now, some lawyers will do that for free, usually in the personal injury realm, because those are generally contingency cases. And when you're dealing with a contract, if you're coming in just to have it reviewed, usually there will be a fee, which will be a shortened version or a shortened amount of 1 hour of that lawyer's time. And what that's going to do is give that lawyer a chance to read through that contract, explain the terms, give you what your rights are, and really give you a breakdown of where you stand in dealing with that type of damage, that insurance company, and that insurance contract. Because you have to understand that insurance contracts are fluid. And what I mean by fluid is not necessarily your contract. What I mean is they develop over time as insurance progresses, develops, evolves, whatever you want to call it. So, an insurance contract from the 1980s is not going to be the same as an insurance contract from 2025, generally speaking. And most people know that. Most people know that these terms change. But what they mean, the definitions, case law that has come out that has imposed certain duties, definitions, rights, or obligations on one party or another are, always in development. There's always litigation going on. And so my recommendation always is have a lawyer look at it. A little bit of pre-preparation or knowledge can save you a lot of hassle on the back end. And so, you ask, do you have a right to get your own contractor? You always have the right to have your own contractor evaluate the damage. Whether or not they have a right, the insurance company has a right to either decide who that contractor is going to be, or if they have a right to, limit the cost based on what they find reasonable, provided it's done in good faith, which I'll go over here in just a second. That really depends on your contract. So And whether or not you want to engage your own contractor really depends on whether or not you believe insurance is treating you fairly, whether or not you believe that they are acting in good faith. And what good faith is that they have a duty under the law to do a reasonable investigation, a good faith investigation into your claim, and not just deny or cut price arbitrarily. That's the simplest way to put it. And so what that means is that if you feel that your insurance company is not reasonably evaluating your claim, it is absolutely a good idea to get a lawyer. It is also absolutely a good idea to potentially retain a lawyer if you feel that this is egregious. If you feel that they are really underbidding and underpaying your claim, it is much better to get someone who can argue contract terms and argue insurance terms and have those discussions and be able to file litigation before your time runs out to be able to do so, and to know all of those things and be able to step in for you. And so a lot of times the way I put it is, if you feel that you are going outside of your knowledge base or something, or into an arena where you may have to argue this in front of a judge or some other third party, it's time to request a lawyer to step in. Okay? Now, it is your choice, but at the bare minimum, definitely have someone review that type of contract for you, tell you where you stand, and then if you are literally meaning opposition instead of just disagreement, usually it is time to retain a lawyer. And they can do that either on a percentage basis or they can do it on an hourly basis. And there's a lot of discussion there. So don't be afraid to come and see a lawyer. It's not going to be usually, I can definitely say this in my firm, I don't want to speak for everyone, but I can definitely say it's not going to be a sales job. It is not going to be a push to get your case. It is going to be an evaluation. So don't be afraid to come and see a lawyer. We're not usually mean.
Very valuable information, especially as we come into tornado season, dealing with storm damage, hail damage, damage from tornadoes. Very valuable information to have when living in the Tennessee Valley. Mickey, do you have anything you want to add?
Just that, in any kind of an agreement, whether it's an insurance contract or any other agreement, even like in my area of family law where I'm reviewing a settlement agreement in a divorce or a custody case, I always would tell a person to have a lawyer look at it. People will call me and ask me if I can look at this proposal that somebody has sent to them, and I'll tell them, yes, come on in, I'll look at it. I'll tell you what it says. If you're in agreement with it, you can sign it. If not, you tell me where you disagree, and we'll talk about it. And so I think that holds true in any agreement at all, whether an insurance agreement, a contract to purchase something, a settlement agreement in a family law case, or anything. So.
Yeah, and to follow up exactly on what he just said, is that really the defining line, is, for me at least, on a practical scale, not so much on a legal side, but on a practical side, is if you're meeting with mere disagreement, you can talk. If you're meeting with actual opposition, it is time to get someone else involved, usually.
Yeah. One thing too is that you want to be able to understand what you're about to sign, because with certain exceptions, once you sign it, you're bound by it. So.
That's exactly right. And I imagine that being able to meet with an attorney, have peace of mind of the contract that you're signing is valid and hopefully in your favor a little bit, that the peace of mind of having an attorney to evaluate that and give the green light on that is immeasurable, on feeling that sense of satisfaction and peace of mind of knowing that this is a good contract to have. So thank you guys for that. So on a personal note, how do you guys feel about being an attorney and just practicing law in general? What do you love about it? What do you maybe find a little, bit irritating or struggle with it? Because, it comes with every job. But just tell me about how you feel about being an attorney and practicing law.
I will tell you, I absolutely love it. I would not do any other job on this planet. I love it because I love knowing how the world works. And when people come to me You know, they're coming to me, whether they realize it or not, and usually they do, to solve a problem, to bring it to a conclusion in one form or another. Litigation is part of that. Argument is part of that. Standing up for my client is part of that. You know, being in an adversarial system is part of that. Knowing the law is part of that. And so you have all of these subsections to it that people think of when they think of a lawyer. But to me, it comes down to, I am here to help them solve a problem. And that's what it amounts to, no matter what it is, whether it's family law or criminal or contract or civil or, you know, a car accident, no matter what it happens to be, we are here to solve a problem and to give them advice in the proper way to resolve it, so that you're not trying to solve it by wasting your time, wasting your effort, wasting your money. And, you know, that's what I love about it, is the ability for people to come to me and me help them solve a problem and gain understanding of that problem before we even begin the process. What about you, Mickey?
Yeah. For me, I developed interest in the law as far back as high school when I took a class called Seminar for Law and Justice.
Oh, you knew early on then.
I did. I was about 16, 17 years old when I developed that interest. And I had the same teacher for the government class the next year. And so I've always been interested in the law. And when I got to law school, I absolutely enjoyed every class that I took. And I heard other classmates complain about this class or that class, but I loved every class I took. And now then, I've been practicing for 27 years. And I didn't necessarily start off to be family lawyer. It just, that's what gravitated and came into my door. But I've gotten where I know it pretty well, and I enjoy doing it. And for me, it's the idea of the dichotomy of stress but fulfillment. Because it's a stressful environment, because so often you're dealing with the custody of someone's child.
Yeah.
But it's a fulfillment that you have in being able to help someone who comes to me and says, this is what's going on in my child's life. And then I can help them in some way. If it means getting a change of custody, or if it means changing something about the visitation schedule, or admonishing the other side to stop doing this or stop doing that. In some way, I've been able to help that client, and I get fulfillment in that. So you know, I get my enjoyment from.
I could definitely see how being an attorney, helping people solve their problems, how that could be very rewarding and give you that sense of helping your fellow citizen, helping your fellow community. Very rewarding, and I could imagine.
So I guess to wrap up, for me, is the challenging part is never having enough time. I always want to do more.
Definitely.
And because I love it. It's just like when you're sitting at Thanksgiving and you're full, but they bring out the dessert. That's
Gotta
where
make room.
That's my life.
Well, thank you guys. Thank you for all the valuable information answering today's questions. And thank you guys for tuning in to North Alabama Law Review. Please send in any legal questions you have. You can send it to legalhelp@jmmtlawfirm.com. And that email will be put on the screen for you to see as well. We would love to hear your feedback, answer any questions that you have. And thank you for tuning in, guys. Thank you.